Good evening. There's lots to say this evening, so I think we better get started so we can squeeze as much of it in as possible. My name is Paul Kennedy. I'm here on my own choice. I wanted to be here because I think this is a very important topic, but on behalf of both the University of Toronto Faculty of Law and the Centre for Addiction and Mental Health, CAMH, they're the sponsors of tonight's event, and I want to welcome you on their behalf. Before doing so, I want to read a statement. I want to do this too. In fact, I wish I didn't have to read it. I wish to acknowledge that the land on which the University of Toronto operates is interesting space. For thousands of years, it has been the traditional land of the Huron-Wendat, and then the Seneca, and most recently the Mississauga of the Credit River. In fact, I've done radio programs on the Mississauga of the Credit River, so I'm happy to be able to talk about the heritage of this land in that context. This meeting is taking place on their homelands. To many Indigenous people from all of the Turtle Island group, this is still considered homeland, and we're grateful for their hospitality and allowing us to do something they did on this land as well, and that was have important conversations. This is an important conversation. It's also something called a catalytic conversion, and that involves you. So eventually I'll later on explain the sort of course of the evening, but we're very much looking for audience participation as well. In June of 2016, Canada passed a law called Bill 116, passed it into law. It's a law that allows eligible adults to request medical assistance in dying, but it specified very important things. One, its only specific circumstances were going to be legitimate for such a request, namely, when a person suffers irremediably, or when death is reasonably foreseeable, and the person must also be in an advanced state of irreversible decline. Now, that meant that people who had standalone mental illnesses were explicitly excluded from this act at that time. They're largely considered ineligible because the legal criteria specified by the law was not met. But the government did have different intentions. They indicated at that time that the criteria introduced in the bill were very specific, and they were excluding certain groups, including minors, by the way, and individuals who have standalone illness, but it was argued that that might change over time. And that is a context they also made room for. The government said that it was committed to having legislation make a further review, or having a further review before further legislation was presented to determine whether and how the law should be expanded. And in December of 2016, just last year, very recently, they announced that that review will be conducted and must be completed by something called the Canadian Council of Academics. It must be tabled in Parliament and available to the public in December, not of this year, but next year, December 2018. And so the question, whether medically assisted dying should be possible for people with mental illness, it's very complex. It's also very much alive. These are topics that are on the table for everybody to think about and talk about and add their opinions to right now. This is a first-off effort. This is a small room also, and this is a very focused conversation because it's the beginning. It's not the end. And there will be many conversations like this that will be convened under the auspices of CAMH and of the University of Toronto Faculty of Law, because there are very important questions to be asked here, and they're not just medical or legal questions. I would say they're moral questions as well, and the context, therefore, is that we have to talk about this stuff. In subsequent conversations, we will be focusing on a wider variety with people who have lived experiences of mental illness, who have interest for other reasons, either maybe their family, maybe their friends, any context at all in which you have a direct interest will be addressed in other conversations further down. Tonight, though, this is the first of a series of catalytic conversations, as I said, and it's a very rich topic. The format of the evening is this. First, we will hear a presentation by Dr. Scott Kim. I will introduce him in a moment. After that, there will be a catalytic conversation with the four people. I'll exclude myself, but four people here on the panel who will be talking about the topic, and those people are Trudeau Lemon, who is at the Faculty of Law of U of T, Kevin Reel, who is a bioethicist and a CAMH psychiatrist, and Dr. Ajee, I'll introduce him as well later. We're going to end the evening, though, as I said, by including you in the conversation. And that's one of the reasons I wanted to be here, and it's one of the reasons I think this evening is important. We will be opening up questions from the audience, and I'll read a rule book then about what those questions, or what form they could take and how they should go. But I do believe it's important, and it's a topic that all Canadians should be talking about. The event this evening is being live streamed, so I wouldn't encourage you to open your laptops here because you're actually dealing with it in real life, but people can be watching and will be watching from home and from other places, I'm sure. A recording of the discussion will be available on, I think, both the websites of CAMH and U of T very soon, I assume. Now the really important information. I'm going to pour myself a glass of water while I tell you the washrooms are available. Not that I will use it, but you might want to. The washrooms are, in fact, down the hall. The folks in the Monk School would like it if you only brought water back into the room, not any other drink or any food, anything of a food nature. So water is the nature of the fluid we're drinking here today. And beyond that, I think we should get things going because, as I said, we have a lot to talk about. I just met all of these people for the first time, so I can't speak from any deep personal connections or background. Dr. Kim, Scott Kim, is a senior investigator in the Department of Bioethics at the National Institutes of Health. He also has a number of jobs, at least two. He's adjunct professor of psychiatry at the University of Michigan and of neurology at the University of Rochester. I won't do this with the others, but I will do it with him because I guess in some ways being the host of a radio program called Ideas gets me interested in the sort of pedagogical background of people, and this one is a pretty good pedigree. Dr. Kim received his MD from Harvard, his PhD not in medicine, but in moral philosophy from, in fact, Kantian ethics from the University of Chicago, and he trained at Mass Gen in Boston. He's got interests that are obviously eclectic, philosophical, clinical, empirical. He continues his interest in all of those topics, which inform the kind of presentation that he is about to give. Please welcome Dr. Kim.
Okay, thank you, Paul. And thank you for inviting me, and thank you for the organizers, and to be part of this really distinguished panel. And I especially want to thank you for giving me a couple days of reprieve from down south, where it's actually really nice to be here and not, you know, you sort of know what I mean, I guess. So I thank you especially for that too. All right. So I was asked to give a brief talk. My main job is, because I've done some work studying actual jurisdictions in which this topic is actual practice, I'm going to give you a quick run through. Okay, that's the main point. So you don't have to know all this. All right. So I'm going to, you'll see, I'll use the term euthanasia and assisted suicide. I know the Canadian term in the law is medically assistance in dying MAiD, but the data and the research and the legal term used in Netherlands, which is mostly what I'll talk about, is euthanasia, basically. So that's what I'll be referring to. And I'm going to be speaking specifically about what we will call psychiatric euthanasia. It's not the best term, but it's the briefest term to cover this whole point, which is that it's euthanasia performed not in people who are dying of cancer who happen to also have a psychiatric disorder, but for the primary indication of a psychiatric disorder. So quick slide gives you an overall trend in Netherlands for overall all euthanasias. You see the increase over the years. 2015, it was about 5,600. In terms of psychiatric euthanasia, it's a very small proportion. It's about 1% of all euthanasias, but the frequency, as you can tell, is increasing. It's about, in 2015, there were about 56 cases. This is Belgium, which is the other country that has legalized the practice. And you'll see they have about 2,200 per year, as recently as 2015. And they don't really break down the exact number of psychiatric cases. They have a broader category of mental behavioral, which includes dementia, so it's hard to tell. My guess would be it's about 40 cases a year, so proportionally it's more frequent in Belgium. In terms of non-terminally ill persons, which is relevant for tonight's discussion because these are people who are not going to die in reasonably foreseeable future. In Belgium, it seems to have plateaued. About 15% of the people who are euthanized in Belgium are for disorders that are not terminal. Okay. Just wanted to give you a quick glimpse of the actual law as it is written in the Netherlands that regulate the practice. So it's divided into two parts. These are what they call the substantive criteria for eligibility. And basically, they break down into two broad issues. One is informed consent, right? So you have to be competent and so forth. So that's A and C. And B and D have to do with the condition that they're in. So there is the unbearable suffering condition, which is essentially identical to the condition that's in the current law here, and no prospect of improvement or the futility aspect. Okay, so it's very similar. And then there are procedural requirements, consultations, and making sure that you use the right drug and so forth. Okay. I should preface with the data that I'm about to present with this statistic, which is really interesting. In 1984 was the first publicized case of what we call psychiatric euthanasia or assisted suicide. Since then, it's been over 3 decades, but even with all that discussion, even with the fact that over 80% of the Dutch public, for example, and doctors are very supportive of the practice of euthanasia per se, usually people who are terminally ill. However, when it comes to psychiatric euthanasia, even now, the support is pretty low. Only about 28 to 35% of the public and the doctors approve of the practice. And a recent survey asked doctors, can you conceive of yourself, granting a request to do psychiatric euthanasia? And only about a third said that they could conceive of that happening for them. So even after 3 decades, it's a fairly low-level support. Now, I've published several papers on this topic, and what I'm going to do is to just briefly go through what the patients look like, how physicians seem to implement the criteria, and then how the review committees regulate this, okay? So the main thing is that even though the paradigmatic cases tend to be, treatment-resistant depression of a person who's been depressed for many years and so forth, which is a very important case, the actual practice, once you have it, it covers all types of psychiatric disorders. So psychotic disorders, schizophrenia, cognitive impairment, mental retardation, people who have had impairment due to other illnesses, autism spectrum disorders, eating disorders, anxiety disorders, and I left out, but I'll cover personality disorders as well as grief, pathologic grief. So, for example, I have 2 brief case descriptions to give you a sense. A woman in her 70s who had schizophrenia since childhood. Her head was continuously occupied, she said, by voices, commenting on everything she did. She felt like she was staying in some sort of labor camp and was possessed by the enemy. And she requested euthanasia from her doctor, who said, no, I don't think I can do this. She received it through a mobile clinic specializing in euthanasia for people in the Netherlands. And there's sort of, you could say that's the other extreme end in terms of kind of the scale of psychopathology, you might say. This is a woman in her 70s who had made a pact with her husband that if one of them died, that the other person would not go on living. He died, and while he was alive, they felt that it was a waste of time to spend time with anybody else except with each other, even at parties. Now, she didn't feel depressed at all. This is the consultant's description of the patient after interviewing her and talking with her. She ate, drank, and slept well, and she followed the news and undertook activities. However, she suffered from the fact that she felt abandoned and that she thought her life was a living hell and life had no meaning. So she was euthanized after 1 year after her husband died. The makeup of the patients, it's mostly women. It's over 70% women. In cases of completed euthanasia of psychiatric causes in Netherlands. And among the requesters of euthanasia in Belgium for psychiatric reasons, it's still over 70%. Majority have personality disorders. They're younger than the people who would receive the other medically based euthanasia. History of suicide attempts in over half. And however, psychiatric admission was in 80%, so 20% didn't have the kind of disorder that required admissions. Social isolation and loneliness is a very prominent theme in the reports. 56% described as either isolated or lonely, and the descriptions are really striking. And I had these translations multiply checked to make sure I got it correct. A patient was described as this: the patient indicated that she had had a life without love and therefore had no right to exist. And a man, the patient was an utterly lonely man whose life had been a failure. Now, these statements occur in part of the reports where the justification for unbearable suffering is stated. So this is part of that suffering that they're going through. Futility, in other words, things aren't going to get better even with treatment, includes the cases where people refuse treatment. So most do get extensive treatment. Unlike the country I'm from, the statewide insurance and so forth is actually much better in terms of coverage, so that people get extensive treatments. However, 56% of the cases involve patients refusing at least some type of treatment. Decision-making capacity discussions in the case reports that we read are relatively, I don't know what the right word is, I'll just describe it. So there's very little discussion of capacity of patients. So remember the woman with schizophrenia I mentioned earlier. The only discussion about that woman's decision-making capacity is a single line that says she was determined to have capacity to request euthanasia. That's the only thing that's in that report. So most cases are like that. And patients can actually fail an established criterion. Like a doctor will say, I don't think this person can reason adequately. And yet that same doctor will say, however, I still think she's competent. So you see cases like that. And then there are disagreements among doctors. On 8 to 10 cases out of 66, there are disagreements. No resolution is really required by the review committee. Their prior history of refusals, about a third of the patients had been refused euthanasia before by their own doctors, so that 18 of the patients received euthanasia from a doctor new to them. Overwhelming majority of those people receive euthanasia from the specialty mobile clinic designed to provide euthanasia for patients who are refused euthanasia by their doctors. The consultation process, in 66 cases, there was no independent psychiatrist. Now, my definition of independent, I have to tell you, is not the legal definition. It's a little bit more generous, meaning if the doctor just called up a second opinion of somebody who works in the same facility, I counted that as a second independent in the sense that they're not involved in the treatment of the patient. Even with that fairly generous, there was, in 7 cases, there was no independent. So there were actually 20 cases in which it wasn't official consultation by psychiatrists, and I counted that as independent. So this is a very conservative number. In one case, there was no psychiatrist involved at all in the evaluation of the patient. In a quarter of the cases, there was disagreement among consultants regarding eligibility. Interestingly, there was this interesting pattern. Of the 16 of those cases, which is about a quarter, the psychiatric consultant is called. The psychiatric consultant says, no, I don't think this person is eligible. The person who called the consultant said, well, I'm going to get another consultation. This time they get a general practitioner who says, I agree. And in 8 of those cases, they go ahead and do the euthanasia. And then, but curiously though, generally the review committees do not comment on the sequence of events. Oversight committees, about 0.1% of the cases are found to be due care not met. So that the cases I gave you, the law criteria I gave you, so the review committee reviews every single instance of euthanasia in the Netherlands, and they just review the files. And I think if you add it all up, since they've been keeping track, it's about mid 40,000s, I would guess. And out of those, only about 80-some people have been found to been evaluated inadequately, you know. So I don't know. Can I just run through the Belgian? Okay, so he's not paying attention, so I'm just going to take that as a yes. So in Belgium, there was one study done by a private psychiatrist a single psychiatrist evaluated 100, during the periods of 2007 to 11, 100 requests for euthanasia for psychiatric reasons, and 100 consecutive. And out of those 100 consecutive requests, 57 were not given euthanasia, in the sense that 38 withdrew their request after submitting their request, 11 withdrew after getting approval, and 8, this was the phrase that has, I don't know what it means, it says continue to pursue their request. The remaining 35 received euthanasia, 6 died by suicide, and 2 died by either palliative sedation, 1 and 1 by complications of anorexia. The 35 who received euthanasia, I am pretty sure after comparing the records that this accounts for this single psychiatrist being responsible for virtually every case of psychiatric euthanasia in Belgium from 2007 to 2011. Her patients were also mostly women, personality disorder very common, much younger than the Dutch group. The case mix in terms of diagnoses was quite varied. One thing I want to point out is that there was an inordinately high number of people diagnosed with autism after they were referred to the psychiatrist, who after seeing them, they got fresh diagnosis of autism. And notably, all 100 consecutive patients presenting to the psychiatrist were deemed both to be suffering unbearably to meet that criterion and also to be competent to make that request. So there it is. There was a follow-up, 57 of the 57 persons who were still living at the end of the initial evaluation period. It said, in the report, it says 9 cases, their requests were still in process. But of the other 48 cases, the requests were, quote, on hold because they were managing with regular, occasional, or no therapy. This is 84% of those who are alive after initial evaluation who were managing apparently okay. So my last slide, I'm just going to throw some provocative thoughts out for an interesting evening. So I think that one way of summarizing what I just told you is the accuracy of medically assisted death eligibility judgment will be different in the cases where people have a reasonably foreseeable death through a medical illness. You know, doctors can be wrong about when they're going to die. It could be 6 months, it could be 12 months. You know, we're not so good at that. But the fact that they're going to die in a reasonably foreseeable future is not that, it's not as, how should I say, as unreliable as having the same kind of judgment making about psychiatric patients, about whether they're going to be futile, whether they're going to change their minds, and things like this. Given this likely difference, how many errors, so remember, this is a medical intervention, so if you implement it, just like any other medical practice, you have to expect there'll be benefits, there'll be side effects. So in terms of medical errors, so to speak, of people who shouldn't have received euthanasia receiving it, so there's an interesting policy question of how many cases of errors are tolerable when you implement a policy like that, especially given that euthanasia is a permanent and irreversible intervention. So I thought that would be a provocative way of starting off the evening as my last slide. Thank you very much.
Thank you, Dr. Kim. It was provocative, not just with the last slide, but earlier things, and I have a lot of questions I could ask, and I'm sure there'll be many more as well. So a great start to the evening. Thank you. I'll now introduce the other three panelists and prepare for opening things up. Dr. Trudeau Lemons, right at my side here, is a professor and the sole chair in health law and policy at the University of Toronto Faculty of Law, which is slightly to the east of us here. He holds cross appointments in the Dalai Lama School of Public Health and the Faculty of Medicine, including psychiatry, the Joint Center for Bioethics. He does research on the interactions between law, governance tools, ethical norms, and values in terms of healthcare. So that brings him full square right center to talk about these issues here tonight. Kevin Reel is a member of the Joint Center for Bioethics Task Force on MAiD since it began. He's currently working as an ethicist at the Toronto Centre for Community Care Access Centre, CCAC, for those who are into acronyms. After completing the JCB Fellowship in Clinical and Organizational Ethics, Kevin has been an ethicist at the South Lake Regional Health Centre, the Mackenzie Health, and Centre for Addiction and Mental Health. And he's also an assistant professor and graduate member of the Department of Occupational Health and Occupational Therapy at the Dalai Lama School. And finally, Dr. Tarek Raji is a psychiatrist. Dr. Raji is the chief of psychiatry, in fact, of geriatric psychiatry. He's also a clinical scientist at the Center for Addiction and Mental Health, CAMH. He's also a Canada Research Chair in Neurostimulation for Cognitive Disorders and associate professor of psychiatry at U of T. I understand that all of these credentials are listed on documents that you have in your hands, so that's why I'm reading through them badly, and you can read those probably better than I could. I'm going to begin by asking all of the panelists, each of the panelists, to answer the same question, and this will give them give you an opportunity to sort of figure out what they think in terms of the conversation, the more open conversation we'll be having later. And the question will be, and I'll be starting at this end and moving towards the other end, so Dr. Kim will also have a chance to answer the question. It's the big question. It's the question I'm sure is on many of your minds right now. Should medically assisted death be available to people with mental illness as a sole underlying condition, that mental illness is the condition that qualifies them for assisted suicide or assisted death? First off, Dr. Lemons. No, this one here. Oh, but I should also point out, by the way, Dr. Lemons has a hearing difficulty, and so and it might not be ameliorated necessarily by the microphone. So when a question is asked from the audience, and plainly also for me here, he really needs to see someone talking. I will transcribe or try to transcribe short form versions of your questions for him eventually. Sorry for the interruption. Back to you.
So I would, legal scholars and lawyers tend to turn around the question. And so I would put up front the question, how did we get here? Why do we have even a discussion about whether mental illness should be the sole basis for access to medical assistance in dying? Because there are only a very few countries in the world that basically offer medical assistance in dying to people with mental illness. We did have, there's somewhat of a historical reason, a very recent historical reason why in the Canadian context we have this discussion. We had a trial case in the Carter case, we had a Supreme Court case, appeal court case, and a Supreme Court case following, which really didn't focus on the mental health context, which was really about exceptional circumstances of people with declining capabilities, arguably in the context of end of life. There's some discussion about whether all of these people who were asking for the right to have medical assistance in dying were close to that, but I think people agree that these were exceptional circumstances. It's also what the trial judge in the Carter case explicitly stated, namely that if there is such a right, if there should be a right, if we should provide medical assistance in dying, it should be in exceptional circumstances with stringent safeguards, and it's never just a question about individual choice, it's also about introducing safeguards that protect against errors, protect against the potential abuse of vulnerability, or even simply against self-choice of people who are vulnerable. And so the Supreme Court provided some general guidance to the legislator to implement legislation, which contained actually quite broad terms. The broad terms were subsequently in parliamentary debates, but even in the reports that came out here before that, interpreted as being very broad, that they should include mental illness. And it created an expectation, I think, that this is an obvious thing. So the Supreme Court made a general statement. Obviously, it should include all kinds of diseases. The legislator comes out with more narrow criteria, and there is an uproar. There is a kind of an uproar about, well, the legislator is actually restricting access to something that should be seen as a right. But if you look at the history of the case, it's interesting. The mental health context was not on the table originally. I think even the advocates for open access were probably surprised that it moved so quickly, that we moved so quickly from exceptional, broadly conceived end-of-life situations or cases to it should be given as a right, which I think is not in the Supreme Court decision. It's certainly not in the trial decision. And so the question is, are there specific concerns that we move further than most countries, even the countries that have allowed, for example, physician-assisted suicide, the several states in the United States? Is it necessary that we move as far as Belgium and the Netherlands, or are there specific concerns? Is there a special need for it? Will it affect the treatment of what I think most of us would agree with in the mental health context are among some of the most vulnerable people in our society? So is there a reason why we should exclude it? And I think this is a discussion that we should be having. I think there are particular reasons to be concerned because of the fact that the safeguards are not necessarily sufficient to protect people against premature death. We're not dealing with people who are close to the end of life. We're moving away from the end of life context where the decision between active ending a person's life and withdrawing of life support is thin. We're moving to a situation where we have people who may have many, many years to live, who may, in a moment of weakness, have their life ended. So that will be my kind of general answer to that. Mm-hmm.
Thank you, and I think you've proven the case that you should be on the panel because these are legal distinctions that need to be talked about, and I thank you for being here, and thank you for the presentation. Next up, Kevin.
Thanks, Paul. My apologies if I start to cough a lot. I've been nursing a hacking cough for 2 weeks now, and I might have to chew gum to keep it at bay, so it's not something I would normally do in this context. I guess the first thing to say is that what is absolutely not lost on me as somebody who will probably be the lone voice out on the panel for wanting to consider this a little bit further in terms of allowing access for people with mental health concerns, is that the gravity of it is not lost on me by a long shot. I have family, friends. When I was an occupational therapist for many, many years, I had clients and I've had colleagues who have ended their own lives, sometimes at a point that I would probably have said was not what I would like to reframe as a rational suicide, but others, cases in which I think there probably is a very good argument that it was a rational suicide. Some of those were end-of-life situations where people had degenerative illnesses that were quickly taking them away from this world, and others were intolerable lives that weren't about to end on their own. And I suppose from many, many years in practice as an occupational therapist, working with pretty much every kind of client under the sun because of the type of work I did when I was working in the UK, I came to understand that there is what I've come to call the perverse lottery. And actually there's a few of these perverse lotteries that we all have tickets for. And many of them are tickets that we don't want, but we have to have one, which is about the end of life one. And then the other one is just about how lucky we are as we move through our lives and what kind of things end up being part of our life experience or not. And in a way, what's been happening over time is that advances in medical practice and psychological practice and social care have been improving the odds for many people. What it's also done is created worse odds for others, created odds that wouldn't have existed before. And in the context of an assisted death, I think when you're thinking about mental health, it's immediately counterintuitive to think this could be something that we might want to offer somebody who's got a mental health condition. And it's also counterintuitive to think we would begin to entertain this where somebody may have years left to live. And it's only when you begin to really probe the life experience of somebody who may not have a terminal illness, but is saying that the life that I'm able to lead is one that I myself, I'm not speaking for anybody as a whole, I'm not speaking for any diagnostic category or any group of people, I myself find it not worth living. And it's a matter of meaning and purpose. And those are highly individual questions. They're based hugely, fundamentally on the values that we hold as individuals. And if I can say capably, and that's going to be the main point, I hope, of much of the discussion tonight, if I can say capably, meeting all those criteria that are in the law, except that I don't have a terminal illness, if I meet all those criteria, then it seems unfair to say just because you got that lottery ticket and not that one, you don't get to have an assisted death. And for some of those people who didn't get that lottery ticket, which allows an assisted death, they have a slightly better lottery ticket, which is that they can withdraw something that's life-sustaining, or they can withhold starting it. So they've got a slightly better lottery ticket. And I've worked with many of those clients who withdraw life-sustaining treatment or withhold it. And sometimes, when I'm struggling to help the staff I work with to understand why this person is doing this, or the fact that we're actually allowing them to withdraw a life-sustaining intervention, I'm left trying to explain that this is not what they think it is in terms of it being an assisted suicide. And I use suicide in scare quotes for purposes that are very deliberate. This is very similar to that morally, because that's the intent that this person has when they say, stop this now. It's not legally the same thing, because we can say it's withdrawal. And then you get somebody who's got not quite so good a lottery ticket, and they don't have anything to withdraw. And one of the most, I think, unmerciful comments I hear in that context is, well, they can always kill themselves. And I just sort of stop in my tracks and think, have you pondered doing that yourself ever? And so it's when you move away from the non-terminal situation and you can consider the possibility, and I'm not wanting to say that this is going to be a common thing, and I'm also happy to say that most of my practice life, I have done work endlessly to help people find meaning and purpose. They're some of the very core endeavors in occupational therapy, to find meaning and purpose in a context where they're struggling to find that. So I do my best to advocate on that side as well. But if they can't find that, then it seems unfair to say that because you ended up in that group that doesn't have this ticket, we're not going to actually do what we can do to level the playing field. Where, again, the important thing is you've met the criteria that we set for thinking this is actually morally okay, and the safeguards are implemented and monitored in a way that we can feel hopefully relatively confident about. I don't doubt that what Scott presented raises numerous alarm bells for people. What I'd like to suggest is that you go to Scott's paper and you look at what his two objectives were in the study, read the two very brief conclusions at the end, answering what he found about those objectives, and then look at the stuff in between and think clearly about how much of this is what we'd call evidence, or how much of this is actually raw data. And to imbue it with meaning is probably a little bit beyond what you can do with those sorts of things. And I've had a partner who for 25 years has worked in human rights practice with Amnesty International, and then teaching it for a few years at Oxford Brookes University when we lived there. And he's always talked about teaching practitioners in the human rights field not to ever make the mistake of reducing a person to a few comments in a report or a witness statement that they take. And my fear is that when what your research is based on are mandatory case report summaries, those summaries are by definition the reduction of a whole person's life, and I would argue the therapeutic experience they've had in all the work of all the practitioners that are involved, to very, very minimal amount of text. And it's really difficult to, I would argue, take anything that's particularly meaningful out of that and to call that evidence. It certainly raises alarm bells. And I absolutely wish and hope that as it progresses in Canada, we can do it better, and we can certainly monitor it better. And I know my colleagues and I are aware that people are struggling because it's so vague, and people are struggling because they're not very well educated and they don't have a lot of practice resources. But I think that if you sit with it and get past the counterintuition that this is just plainly wrong, which I would agree that I've felt for years, and you start listening to the people whose, as we mentioned earlier, their voices aren't here tonight, the people that are requesting this for particular reasons based often on decades of life experience and attempts to remediate the situation, your thinking can begin to change. And again, hopefully in very few cases, as it says on CAMH's website and their public the only public statement about assisted dying, in some very few cases, conditions like this may be irremediable. And we have to make sure that then people are making an informed and capable choice.
Thank you, Kevin, for, I think, showing us the spectrum in some ways. Finally, Dr. Tarek.
Thank you, Paul. And so I'll talk a little bit, but I think the conversation is starting in a way because I hear some kind of responses. So I think part of what I'll be talking about is maybe addressing some of the points that were raised. I think also, like it was mentioned, this is the first of a catalytic conversation where there will be others, and I think one of the others the panel will consist mostly from clients and clients representatives, which we don't have here among us at the table. To me, to answer the question directly, as a psychiatrist and as a clinician, also as a clinician scientist, I think, in a way, I do not think that people should not be eligible for MAiD just on the basis because they have mental illness. So I don't think we should have that as an automatic exclusion criteria. To me, the way I see it is more, it's hard for me to see how people could meet the eligibility criteria if it was on the basis only of mental illness. And I say that from two perspectives based on the original criteria. One could be around the issues of capacity, because it will be hard sometimes to meet this criteria based on capacity. The other issue from clinician perspective, and I think clinician scientist perspective, is the remediable nature of the illness. And I'm not sure that we are at a stage in the science of mental illness to say on an individual basis, that kind of addresses the comment, the last comment that Scott made about the difference between terminal illness and predicting, in some sense, death reliably within 6 to 12 months. I don't think in mental health and mental illness we can, on an individual basis, predict a course of the illness and a specific event. We have ideas, statistical ideas at the group level, but not yet at the individual level. And so that ties into, I think, the third criteria with the C14 bill, which is around, are we at a stage in a specific illness of decline, progressive decline, irreversible decline, And are we within the reasonably foreseeable death in the future of this individual person, the individual person. So in that sense, it's hard for me to see who are the clients who could meet eligibility based on mental illness. And I also say that within a framework and a context that we try to provide care for clients and patients, which is a recovery-based framework. And what I mean by that is that we tend to, in our treatments, we spend a lot of time and as we need to, trying to address the symptoms of the illness. But we try not, as we were trained, not to reduce individuals to just the illness. And while fully appreciating the suffering, some of the discussions we have, and sometimes on purpose we do, is that we in the middle of the interview, in the middle of the assessment, in the middle of the treatment session, we say, let's stop now talking about your illness, let's talk about other parts of your life. And to try to work on enhancing, increasing capacity for other parts of individual life outside of the illness, and rather than feeding into the belief sometimes that clients have, identifying themselves with the illness itself. So this is one way to think of recovery-based model of treatment. And it's hard. That's not easy to do when people have ongoing suffering and real psychological suffering. But I think that's I see it as a psychiatrist, part of my mandate as a psychiatrist. Before coming here, I was in clinic. I have a clinic every Wednesday afternoon, and it was a busy clinic. And there is a client I see on a regular basis that every time I see, I've been having a very difficult time getting him out of depression. He's been having treatment-resistant depression. And every visit I see him, MAiD comes to my mind. He hasn't raised it, but the issues about death and suicidal ideation come to my mind. And we keep trying. We've been trying for years for this individual. Sometimes he did recover, and then he relapses. And we try for years, one treatment after another. It worked in the past. Now it's not working. And and that's what I said today to this individual, is that I know you're not hopeful about what we're going to try again, but if you're willing to try with me, I'm going to stay with you. I'm going to keep trying. I'm going to have you keep coming. So as long as you're willing to be open-minded to having other options of treatment, I'm willing to keep working with you and walking with you. And that's what he replaced. I'm open-minded, but I'm not hopeful. And that part of the discussion, then I emphasize with them to talk about other things that are part of other elements of his life. And that's a lot of the research we do, is trying to focusing on recovery-based interventions, recovery-based treatments that are addressing aspects of the illness that are not related just to the symptoms of the specific illness. I'll stop here. Thank you.
Thank you, and I'm sure we'll be calling on some of your very specific memories or experiences to pepper or spice the conversation up. I think that kind of grounding is crucially essential, and it will appear as was promised in subsequent conversations like this. Dr. Kim, I'll give you the same amount of time, I guess, to talk to the same question. Should assisted death be available to people who just have mental illness as the sole criteria?
Yeah, I'm going to, can you hear me okay? Okay, I'm going to divide my response in two parts. I just wanted to address a couple of things that Kevin raised, because I think it's important to address it. I think he's absolutely right to raise the issue of nature of suffering from psychiatric disorders. I think that as a psychiatrist who's treated very sick patients for many years, until about 3 years ago when I changed my job, it is a very difficult job, and to be with them and to draw on their inner strength to hang on until, we can do better. And the nature of their suffering is extremely important to acknowledge. And then to, because a lot of our patients, it's the nature of being recognized, how isolated and how much pain they feel. Another human being there with them, recognizing that is really extremely important. And I'm going to get back to that issue sometime later in this evening. So I think it's important to emphasize that. And we're all here to try to figure out what is the best response. And I don't think anybody is trying to minimize the seriousness of those, really immense suffering that people are going through. I did want to respond to the nature of the evidence that I presented. I think it's a very fair statement that there are limitations to the data I presented. But I want to call your attention to the fact that what you heard in 15 minutes is all this really scientific, if you want to call it, data that we have about what it looks like when we have this practice. Okay? So you could use the best available evidence, or you could rely on anecdotes. And I agree, you shouldn't take a few quotes and reduce a person to that. But you have to try to come up with and use the best of evidence available. So I've tried my best to what's available. You all can do the research I've done. All the documents I used have been available publicly for years. No one has bothered to read it. No one has bothered to read the stories of these people. Some of these documents have been on their website for 5, 6 years. Why haven't they read it? Well, I think that there is a sense in which some people think that my results create alarm bells. Well, when I talk to the Dutch scholars who are interested in the issue, and people who are on those committees look at my data, and the last comment I got was, well, that sounds about right. So I think that I'm not trying to paint it in a certain way. I've done my best to try to accurately portray what's written in those reports. The reports, by the way, since this is a brief session, I couldn't go into how I got that. They're basically on average, about 1,200 word summaries written by the review committees. And they're based on entirely the reporting of the doctors who have provided euthanasia. So they are written from the perspective of the person who's actually doing the act, okay, from the records and what they did. So I don't think it's very difficult to, how should I put it? Well, let's just say that it has a bias in a certain direction if there is any. I'd like to go back to, I might be the first person who's sort of straightforwardly going to answer your question. Okay, so your question was, as I recall, something like, should MAiD be available to people with mental illness as a sole underlying condition? So let's take that as a question about legalization that applies to a group of people. Now, the premise of that question really is about the fact that you can't really allow this with no restrictions whatsoever. I think most people would agree to that. So the question is, where is a reasonable place to draw the line? Why? Because even if it's a right that people have, there is, in matters of justice, considerations, worrying about the vulnerable, you have to balance the interests. So the question is, what's the best way to do it? I would call your attention to the preamble of the bill. I mean, it's a very good document. The preamble, in very few words, goes through various things about why they have drawn the line they have. And I think it may come up, we can talk about that, but the preamble, I just want to repeat some of the words in the preamble. It's because, you know, this is an irrevocable act. Once you do euthanasia, they're not going to come back and complain whether it was good, done well or not. It's permanent. There's also a need to respect these are the words from your law, I presume is based on the charter rights, inherent and equal value of every person's life, and to avoid encouraging negative perceptions of quality of life. Because I agree with Kevin that, you know, life is really, there is these perverse lotteries. Some of us most people who were able to make it to this meeting tonight are, in some measurable sense, very privileged, okay? And I think that However, we also have a long-standing, hundreds of years of tradition in most liberal democracies that every human being, whether or not they have an illness, whether they're black, whether they're Asian, whether they're whatever, whether you're disabled, have an equal worth. And I think that when you start having measurement about when is it as a society we can say, well, once you have that kind of features of your life, it would be okay for another person to intentionally take it. That does really generally have to be, I think it has to be thought through very carefully. Let's just put it that way. Okay. The preamble also talks about vulnerable persons must be protected from being induced in moments of weakness to end their lives. I think that's a kind of a fairly good layperson's description of the concern we're talking about here, which is this. I think when you have, as I said, a medical illness that's reasonably foreseeable in terms of death, even the most incompetent doctors, if they've talked to the cancer specialist, can say, I think you're going to die. They're not going to be wrong. On the other hand, even the most sophisticated psychiatrist does not have too much data to go on except their own experience and impressions to make these prognostic determinations. I just read in the last couple of days a paper and talked to a person who did research. Well, you know, a person, let's imagine a person with depression. They come into my office, I try to treat them, they're very depressed. 2 months later, not better. 4 months later, not better. 8 months later, not better. 12 months later, not better. I've tried now 4 different medications. I'm trying combinations and so forth. 18 months later, they're still not doing that well. After maybe 3 years, they start to get better. You know, what are the chances of people like that, when years later, when you surveyed them, that they're completely mentally healthy, saying every day is a good day? You know, I found out today, I didn't know this. This is what I mean by the science is just being generated. This paper, higher percentage of people in Canada who fit that description are happier, right, years later than the average prevalence of Americans' happiness, okay? So I just think that this is something that the reason why we're so worried about it is that for those of us who think that terminal illness and euthanasia, it kind of makes sense. It's because for decades, we've thought about and struggled with how to deal with these difficult end-of-life decisions in the face of modern technology. Every society has done that now. However, even in the Netherlands and Belgium, there has not really been the kind of science and the discussion about this issue. Right? It's kind of running into a blind in my view. So I guess, you know, I'm just showing myself to be one of these brash Americans who talks before he thinks. So, okay, so that was not a good joke, but you know. But that's sort of on our minds these days down south. So I think that there are many reasons why I think we could add to this, but let's just, and the other thing is this. Number one protection for why even with people with terminal illnesses, why euthanasia, number one protection against mistakes and errors, you know what it is? Most people who are dying still do not want to die. In psychiatric illness, it's too often part of the illness, even though they can go on living. And for many years later, after 3 years of misery of depression, they might be able to gain that strength. It's part of the illness. They want to die, even though they're not dying. Now, I think that those kind of considerations provide a very reasonable basis to draw a good, practical line to regulate this.
Thank you. I'm, first off, shocked that that is the extent of the evidence that's available. It astounds me that there has not been more work done on it, and I think it's time to start catching up in some ways, and so that's part of what we're at here. I'll begin by asking some questions, and again, keep in mind that we will be opening to the floor later. The first question I mean, I'm not a doctor and I'm not a lawyer, and so I can, in some ways, can distance myself from this. But my question would be definitional, I suppose, at the beginning. And there are many definitions in any act of law, but this particular act has a lot of definitions. Irremediable is one of the words that, as neither a doctor nor a lawyer, I don't know how to define it, but I would like to ask you to define it. What does it mean, irremediable? Yeah. Psychiatrist first, okay.
Great. So what I was going to say, I don't know what exactly it means in mental illness. I mean, that's been my challenge, and maybe I'm wrong. I don't know, but
you're a doctor,
sure,
and you should have an answer.
Exactly. So, but this is so. What do we mean by irremediable? Are we talking about a specific symptom of a specific illness? Are we talking about? I mean, if we talk, for example, patients and clients who have schizophrenia, who it's considered one of the most severe mental illness, chronic mental illness. Long term, more than half of them will have form of a recovery. Some studies, quarter would say full recovery, and another quarter recovery enough to live independently. So what is this? But when people are in the early stages of schizophrenia, or for a lot of part of their illness, it looks like it's irremediable. So how do we define being irremediable? Is it living with an illness, living and having some meaning outside of the illness? Is this a form of being irremediable illness, or are we just thinking about a specific symptom that it doesn't go away? So it is hard for me to define. When because also there is no timeline to predict that progressive decline in mental illness, as far as we can tell based on the science now.
To the complexity of what's irremediable, and so in the context of the court cases, the Supreme Court confirmed widely known principle that nobody can be forced to accept treatment. So there's a historical reason why that has developed over time. In the normal medical care context and the treatment context, it's very intrusive to basically invade somebody's bodily integrity to impose a treatment that they don't want.
But these are requests for treatment.
Yeah, so the right to refuse treatment and the right to basically make self-regarding decisions with respect to what kind of treatment you want to accept is well established in law. But the context in which this happens in the context of in mental health is somewhat different. So again, the idea is you can refuse treatment because you have to decide whether your bodily integrity should be invaded upon by medication, by surgery or whatever. But normally when people are sick, they actually want to have treatment because they want to be healed. And so the cases in which people really refuse treatment, even though it will have dramatic consequences, are relatively limited. It can happen. And certainly at the end of life, for example, well, it may be very reasonable to say, I don't want to have treatment which has significant side effects because I prefer to have a certain quality of life. In the mental health context, the treatment refusal is often is more common, is often part and parcel of the disease, because if you're dealing with people who suffer from severe depression, dying may actually be one of the symptoms, one of the kind of the components of the disease. So it's much more worrisome if you start adding to this kind of context a combination of the right to refuse treatment and the right to ask for active life-ending interventions. So it basically means that you have people who are suffering from mental illness, who may be helped, but who have a tendency to refuse treatment, whose capacity determination may be difficult. So it depends really on individual psychiatrists whether they will identify this person as being capable to make their own decisions about treatment refusal. And so if a psychiatrist is more flexible, treatment is refused and access to medical assistance in dying is being asked. So the consequences or the difficulties of the decision making in that context, combination of treatment refusal and asking for medical assistance in dying because the treatment of refusal arguably would render the disease irremediable, which in the psychiatric context is actually questionable, because even if you don't provide treatment, people may suffer for a longer period of time, but they may recover. And it's very hard to determine who will recover and who will not.
Kevin, you had experience.
Yeah, so I'd just like to ask people to think about the number of times we're hearing qualifiers tonight, which is a testament to how little hard evidence there is. But I also think that it's really important to do something that one author has recently referred to as unlearning. When Marie-Louise Knott was reflecting on Hannah Arendt's contribution to thinking over the years, she described it as Hannah Arendt's journey into unlearning things that she'd been handed, basically. And this is where, in another context altogether, people might know about MIT-Harvard collaboration called Project Implicit, which is about looking at the implicit biases that we carry. And so they've looked at it along the lines of gender and along the lines of Muslim, anti-Muslim names, and those kind of things that we take as our baggage, and also along race lines as well. And the idea that many of us are privileged enough that we can get through life without having to experience these kind of implicit biases, but then occasionally it comes a cropper and we experience them. And the weird thing is that most often people don't know they carry these biases. Sometimes if you were asking them about whether they felt this bias was either existent in their opinions or their behavior, and if they would absolutely refuse to believe it because it completely contradicts their own value set. And one really good example was where a recent study in the States found that a hospital was implicitly disadvantaging female clients, female patients, and it was a shock and a horror to the clinicians involved that the way they'd set up their system had this implicit bias in it. So the implicit bias that I think we need to unlearn is the way we talk about suicide. Because every time we hear the word suicide, we tend to default to this very clear idea of those horrible, tragic events that ought to be the focus of massive prevention programs and fantastic social care programs that mean people don't get there. And then when you talk about suicidal ideation, the idea that like people who are depressed are suicidal, people who want to end their lives are suicidal, and some people who are mentally ill aren't suicidal, but they might actually be different kinds of thinking. And I might be at one point fixed in various ways on my life is better ended. At another point, it might be that some people, and again, I'll argue this might be a very small number of people, but they may not actually be hell-bent on ending their own lives. But over the course of time, and with some people, it's actually over the course of decades, they get to the point where they can't get any way out. Recovery is eluding them. And to think that recovery is always possible and that people will somehow just get better in time is probably statistically a reasonable assumption for many people, but there are chunks of the population, study after study will show it, who don't recover. And that's why, again, you can reference the CAMH statement. It says that the few who are irremediable. And I know Trudeau likes to refer to William Styron's memoir, Darkness Visible. And even William Styron, who got through his period of terrible darkness, in the opening paragraphs of that memoir, he notes that not everybody will actually get better. And so the question for me is then, what do we do? And I don't want to do it in a rush, and I'm glad that there was a bit of a break put on it, but I'm hoping that like this Canadian Psychiatric Association will get its act together and start developing some kind of set of practice guidelines. The fact that we're out there practicing and we don't know when we can start thinking, this is maybe not going to get better with any of these things we try. And there are some people who will actually arrive at that point in practice. And there are people whose care plan is what's called palliative psychiatry. It's not psychiatry and palliative care, It's palliative psychiatry, which means there's no active treatment plan. All we're going to do is try to keep this person comfortable, try to diminish symptoms if that's possible, but in many of those cases, it's about trying to keep that person alive. And it's not because they're going to intentionally die by their own hand, but some of their self-injurious behaviors will amount to their death. And some people have argued, and I agree it's a thin bit of an argument, but it's worth pondering, that in certain diagnostic categories, when you start labeling people that way, and then when you start studying people that fall into those categories, as you do when you work with things like the DSM and the ICF, there are categories in which you can actually statistically note over time that X number of people don't respond to any of the treatments that we currently have available, and a percentage of those die by their own hand. And the trouble then becomes, the real challenge becomes, how do we try to identify those folks? And how do we parse out this idea of the ideations and when those ideations might become behaviors or not, so that if there's no worry that the ideation will turn into a behavior, then we don't have to worry about preventing that as much. But how do we then ameliorate that suffering? Because it's very real suffering that I would argue most of us have a great deal of difficulty empathizing with, because we just can't begin to get our head around it half the time. And a lot of us think about depression because most of us have felt the blues and sometimes certain significant depressive reactions to things. But you know, this partner I've had for 25 years lives with major depression and anxiety. And we've gone through spells of time. Fortunately, any notion of actually wanting to end life hasn't come up. But I look at those things that are those very clear cognitive distortions that I'm hearing. But the beauty for me in this context, and for him in a way, is that he has insight into that. And he can say, I know that this is the disease talking, but I can't get my brain out of that space, even though if you ask me to speak absolutely rationally, I'll say that that's not true. But I can't hold that thought very long, and I'm stuck with this kind of doom and awful terror. And if we can't make that lift over decades for some people, it's a horror to live with. And as much as I think their life is worth every little bit as everybody else's life, if they're telling me that their experience of suffering that's associated with that life is so profound that they'd actually like to cease the living, I got to give a lot of thought to that, because I still think that there may be, with adequate safeguards and a lot of collaborative practice, it's going to require a lot of conscientious collaboration on the part of a lot of people to get there.
I see that all three panelists are really barging to get in. I'll go to Dr. Rigi first.
To start again the conversation leader among us, and I think I want to address some points raised by Kevin, but also some of the earlier points. So I agree a lot with what's been said around the immensity of the suffering and the difficulty among us, and sometimes as clinicians to fully empathize with the suffering of the individual who's suffering, and also to to deal with the counter reactions to the suffering that we have. And I want to make sure that emphasize the point that I think Kevin was alluding to, that not everyone is going to recover. We know that, and people will, some people, a lot of people will die suffering. The challenge we have is that we don't know who is this person, and that's the current state of science and mental health. We really don't know yet who's going to be the person. This is the challenge for me as a physician, and having this discussion. The other point I want to address is around that Kevin raised, and I've thought about it a lot, and I've thought about it also in context of some clients that we've seen in our services who actually completed suicide. And I've had the discussion with colleagues around their completed suicide, even though after recovering from an episode, they completed suicide, about the question, what is suicide in this case? And if we are, and this is really a question that came to me, is that are we having a discussion about demedicalizing suicide? And if it is, if we want to think about it this way, then is MAiD really addresses that part of that aspect of suicide. MAiD is a medical assistance in dying. Does it, and again, really it's a matter of question, should it be addressing acts of suicide that are not considered medical or conceived as I think maybe someone else mentioned the rational suicide. The last point I want to make around the evidence, and again, also a question, if we are considering MAiD as a form of treatment intervention, when there is very limited evidence, as a medical profession or as a healthcare profession, do we introduce an intervention without enough evidence that we don't understand it well? Are we ready to introduce that intervention? So these are questions, I think, as a practitioner, as a psychiatrist, as a clinician scientist, I thought about and I think about now.
Can I just say to that, my job is I'm happiest when I leave a room with more questions than answers. But we're dealing with something that we need really answers to, because this is something that will affect the lives of many, many people. So I'm looking for answers, I guess. And Dr. Kim, you did want to comment here or no?
Yeah, I think one of the things I want to make very clear is that I think we can all very vividly imagine patients, friends, relatives. I can imagine my own patients who have suffered a lot and who are in such a situation such that at some point I will have the thought, you know, I don't think this person's ever going to get better. And we all have that very strong feeling. Now, we may be right, or we could be wrong. But let's say we're only talking about the right cases, okay? The question that was posed at the beginning isn't, what should we do for those cases that we all agree are the right cases? The question that was posed to us is, not knowing who the right cases are, what the wrong cases are for the whole population, given the limits of medical practice and how doctors do things, are we willing to accept the potential errors that will occur? I guess that's the question. So let me just be very concrete. Let's say, I don't think that, to me, having read all these transcripts or the reports, it's pretty clear to me that doctors are not very reliable, meaning they don't agree, and if people disagree, they can't both be right, okay? So given that, and there's substantial minority in which that happens, and the data, the lack of data about prognosis when you have a patient in front of you. So as an example, we talk about, you talked about what's irremediable. You know, in our field, there's this concept called treatment-resistant depression. There are as many definitions of that as there are psychiatrists. And in fact, JAMA Psychiatry just published yet another opinion article about how they think we should start measuring it. I mean, this is 2017. And the field of psychiatry is still debating how to define treatment-refractory depression. But let's say, instead of using that term, you just have very sick patients who have been treated multiple places, haven't gotten better, tried ECT, haven't gotten better, they get referred to a tertiary center, and they get intensive treatment. They did that in England. Of the patients who entered that study, they look just like the patients who received euthanasia in the Netherlands. Okay? 60% of the people 3 years later were doing much better, near remission or meeting remission. Now, that was a very surprising study for people to read. The problem is, at the point when you begin that study, you don't know who the 60% is. And those people are already at the point of having suffered many years. So my point is that if we have a medical practice in which we're not going to, if you make this an available medical intervention, then you have to accept the fact that, you know, doctors are fallible people, and no one wants a situation where, in the name of safeguards, you're going to police doctors second by second to make sure they're doing it correctly, because especially when the definitions are somewhat vague, right? So there will be situations in which people who are not decisionally competent are granted their request. There will be those. There will be people who are competent but make a decision that they probably would have changed their minds. They would, as I showed you, there were people, very people in Belgium where they said, I want it, yes, you can have it, oh, I changed my mind, okay? So there will be people like that. There will be people who would have recovered. Then the prognosis made by the doctors using their best clinical impression will have been wrong, and they would have been euthanized. There will be people who actually may not have improved in their suffering, but their resilience would have been supported through treatment so that their symptoms might be bad, but their desire to live and have faith in the meaning of their life would have continued. All those cases of persons, I have no doubt, and that's just the nature of medical practice. We all do our best, and sometimes we're right, sometimes we're wrong. So to me, the real question isn't, for those right cases that we all agree on, what should be the law? Because that's not what the law is about. Law is about the entire group of people. So how many errors, I'm not talking about abuses. I just want to be very clear about that. I'm not imputing doctors going around doing stuff, you know. I'm talking about doctors doing their utmost, doing the best science available, making their decisions. Given that, how many are you willing to accept as errors? And I think that's a point of discussion that I have not heard discussed explicitly. And I think it's a discussion that's really worth having. Because I think the right patients was we defined it. I think people, I saw you nod, so I'm just going to.
Well, actually, Dr. Trudeau was actually asking if he could talk, and I was thinking, I've really only asked one question, which has taken 25 minutes, and we've only got half an hour left. So in fact, I think I was going to ask one more question, but I think it's time maybe to open to the floor, because I think so. The questions on the floor, this is what I would like to read the rule book on first. Obviously, there's someone with a microphone who will come around. Please indicate your interest by raising your hand. Don't expect to hold the microphone for a couple of reasons. One, it makes a lot of noise quite frequently when people hold it who don't know how to hold it. Second thing, yes, one question generated 25 minutes worth of answers. So keep your questions brief. If there's context required, give it, but try to do it in a sentence or two and get into the question very quickly. I'm not running a stopwatch, but I'm going to make sure that people do that. I've already seen 3 hands, so there's more questions to take us at 10 o'clock now. Go. No.
10 days ago at the University of Toronto, I heard 2 people speak, Jacqueline Downey and Michael Bay. And what they told me, if I got it right, was that competence and capacity boards and courts in Canada have already allowed people suffering solely from mental health to refuse treatment and die within a matter of days. So this takes us back to Professor Reel's question. When we know this is going to happen, we already have a legal floor. It's not whether we're going to have this. The question is, in what circumstances are we going to have this? Every year in the United States, 400,000 people die from medical error. And in Canada, the number is approximately 40,000. We're not looking for certainty here. Certainty, as Voltaire said, is absurd. Uncertainty is unpleasant. So we're asking what's reasonable in the circumstance. We already have a floor. We already know the courts and capacity boards have allowed people in the condition you're talking about to refuse treatment, and in case of anorexics, die within a few days. And so what we're looking for is what we can do that's reasonable in the situation to formalize this in a better way. It's already there. Whether or not the medical profession is up to the task, maybe they aren't. Maybe the legal profession will run this show. Maybe it'll be somebody else. But other than telling a patient who's had years and years and years of struggling with depression, tries all kinds of treatment, and has maybe tried to take their life a few times, to tell them to get a gun, that's what we're hearing now. So I think you need to come up with, if you don't have it tonight, you need to find a way to move forward.
That was more of a statement than a question. Okay, question from the back, please.
Okay, if I hold it? Okay. I just wanted to make a point, actually, about C-14, about the law. Mr. Kennedy, at the beginning of the evening, said that C-14 explicitly excludes persons who present solely or primarily with psychiatric illnesses. It actually doesn't do that at all. It never mentions psychiatric illnesses. One thing it does say is psychological suffering matters just as much as physical suffering. But it may have been the intention of the drafters of C-14 to exclude psychiatric patients, but they didn't do it frontally or facially by doing it in those terms. And you could raise the question, why? And I think the answer is, if you excluded explicitly patients who suffer from psychiatric illnesses, you would be immediately open to a Section 15 challenge on the ground that it discriminates against patients who have a particular kind of disability. So what did they do instead? They used an indirect method whereby, in order to qualify, you had to be in an advanced state of irreversible decline, or your natural death had to be reasonably foreseeable. Those conditions come at a terrible cost because they exclude many, many patients with very serious physical illnesses who don't satisfy those criteria. I'm absolutely confident that those conditions will not survive a legal challenge and will not be part of the law a few years down the road. So if you can't exclude psychiatric patients frontally as such, explicitly, and if you can't do it by these indirect means because the cost is much, much too high for other categories of patients, why don't we stop trying altogether and instead work at the problem from a different point of view? Kevin mentioned urging the Canadian Psychiatric Association to begin to develop practice guidelines. Instead of trying to deal with or avoid the kinds of difficult cases that Dr. Kim and others have mentioned here, which I agree, many of them are hard cases, instead of trying to deal with them by excluding a whole category of patients, why don't we try to deal with them on a case-by-case basis, keeping in mind this is always going to be no more than a very small fraction of people who request MAiD.
That last statement was a question which disguised itself as a statement.
I never claimed it was a question.
You're at the end of your time as a panelist. I just want to suggest
we have another way of going about this, including psychiatric patients, and deal with them on a case-by-case basis.
Thank you. Are there more questions? Oh, panel, yeah.
So thank you. Can I address those two? So thank you for both comments, and I'm going to address them. I think, to me, and this is a personal opinion, but I think we expressed it, at our hospital. Is that's why it's what I started by saying is that I don't think people should be excluded just on the basis of having mental illness. And then I said that it's hard for us to see when it can be applicable. Now, there may be a situation, case by case, where they could meet the eligibility criteria before the foreseeable death, reason foreseeable was introduced, or with the decline, and that could maybe apply to individuals like there was an individual with severe conversion disorder, and where, because my point has been, and in my thinking, and when we talked about, is around really the irremediable nature of the illness. And when there is chronic illness, when there is no terminal end to it, then to me there is always room for remediable nature. When there is clear decline, like in individuals when they stop eating, like with anorexia, are they dying from the anorexia or from the medical comorbidities of the anorexia? I don't know if then we're talking about irremediable illness. So I agree with you. I think it needs to be case by case, and personally, I think the irremediable, we need to clearly define what do we mean by irremediable. And to me, that's why there was two words, grievous and irremediable. They were not just one word.
Dr. Lemons?
So maybe I'll focus on the claim about the constitutional issue. And so I find it interesting in this debate that we've seen the government clearly coming out with the intention. And so this has been a huge debate in the Senate that the government restricted the legislation more to the end-of-life context broadly conceived. It goes to the Senate. People very harshly push to have that restriction removed to keep the criteria much more open. The intention of the government was clear. Parliament has voted on the basis of that. Now people turn around and say, well, the legislation is actually not clear enough, and so you have to include MAiD on the basis of mental health suffering alone. So nobody is talking about excluding psychiatric patients from MAiD. So I think we all agree with that. It would be discriminatory to say that people who suffer from mental illness are in and of itself excluded when they fulfill the criteria of the legislation. That's kind of clear. The question is more, is it reasonable to restrict access to specific, more narrowly defined circumstances, which by their definition exclude mental illness itself because of the fact that it may not fulfill the criteria. If the government would not have restricted the legislation to the end-of-life context broadly conceived, there would already have been a charter challenge as well by people who would argue that people suffering from mental illness are not equally protected under the law against premature death. And so there was so we can discuss about that. It's certainly an issue of constitutional interpretation. Constitutional scholars such as Diane Poitier have argued if we don't ensure the adequate protection of, for example, people with mental illness, there is a violation of their equal protection. So under Section 15. So that would be my response to your claim. We're not excluding people with mental illness. We're limiting access to medical assistance in dying, and in the Canadian context now with the legislation, to specific circumstances, because it is not just about individuals choosing, it's also about the need to protect people. So it's about competing charter rights. It's the charter rights of people who want, in specific circumstances, have access to medical assistance in dying, versus the charter rights of people who need protection, who have to be protected against premature death. And so the question is that reasonable? Did the government or did Parliament enact a reasonable balance? So that can be a discussion, but I don't think the discrimination claim holds.
I find that it's fascinating to think that if they didn't actually recognize that they were discriminating against people with mental illness, then why was mental illness included with minors who were very explicitly removed from it, and people who have at some point in time lost capacity but wrote an advance directive? So the government in the legislation required this review that the Canadian Council of Academies is undertaking now. And the three areas are, curiously, mental health, so they were excluded clearly, although they didn't say it explicitly, advance directives, and minors. And the thing that then strikes me too is that when you go back to the original Supreme Court decision, as well we know, they weren't dealing with mental illness among the people who were the plaintiffs, but they were dealing with a non-terminal illness. So why wasn't non-terminal illness included in the review? Because that's actually a larger group of people who are evidently suffering, many of them with no hope of recovery because of the nature of their illness. So it just makes me wonder why that was excluded when the Supreme Court decision could very, very simply have included the word terminal. And people typically have a way of working around that far more easily than things like grievous and irremediable. And they just chose not to put it in there, which I think is absolutely evident, that they recognized from the affidavits that they received from various people. They're fascinating reading, very, very difficult reading sometimes, but they're fascinating reading, that they recognized the cases of people who had non-terminal illness that wanted to end their life, and that may very well include people who had mental illness primarily as the source of what they're describing as intolerable suffering. So I think that the government, I would argue now, was probably right in bringing in a restrained first phase, but should have kicked off immediately with funding a collective collaboration of not just the Canadian Psychiatric Association, but psychologists, social workers, occupational therapists, spiritual care providers, ethicists, to do something that the ethicist in the States, whose name is Margaret Pabst-Batten, she refers to what she'd engaged in with a colleague, just two of them in this case, was a field trip over to the Low Countries to look at assisted dying a long time ago. She called it oppositional collaboration. And she said, if you do it with people that you share ideas with, you're going to learn nothing. But if you go there with somebody that has a totally different view, you're going to see things eventually a little bit more broadly, and maybe even a lot more broadly. And that's what I think needs to happen, is that some kind of oppositional collaboration needs to come in. And at the same time, I'm a little bit shocked to think that there is all this medical practice going on out there, and there isn't very clear sense of pathways and protocols and a kind of ongoing working group about what can we expect, what have people seen, let's share experiences in a really large way, which we can easily do now with big data, about what kind of responses and what kind of combinations and different types of therapy work. So
we'll go to Dr. Rizzi, and then we'll go to a question from the floor.
So just one comment to put, and maybe Trudeau can make more comment more on this one, is the context, in my understanding, the context of the Supreme Court and the case, there was the case that was dealt with was not terminal, but there was also a context that to address the issue that people be able to end their lives and prevent having them in a situation where they cannot do it anymore on their own. And I think so. I mean that's in my maybe Trudeau, you want.
So the Supreme Court didn't address the equality claim, which makes it harder to say. So the trial judge actually looked at this. So are we dealing here with a situation where people who normally would be able in a position to commit suicide themselves are no longer capable? But the Supreme Court didn't ground it on equality rights. So we looked at it from a life, liberty, security issue. So which doesn't really support the kind of a claim that therefore it's restricted to people who can't do it themselves.
Can I insert something?
Okay, last word on this question or comment.
So I should have said, I'm not a lawyer, and as you know, I'm not even a Canadian. So I'm totally unqualified to talk about how you guys should sort of haggle out all this Supreme Court ruling stuff, which gives me a big headache because I don't really understand all that stuff. But I did want to respond to this gentleman's point about the 400,000 errors in hospitals and so forth. I think it is quite telling. There are 2 points related to that, and I should have qualified, filled out my position a little bit more. Yes, I mean, things aren't going to be perfect. That's not what I'm calling for. But remember, there are 400,000 errors, and there are efforts to correct it. For the kind of errors I'm talking about, you will not know there were errors. You can suspect it, but the people who would actually complain about errors are not there to tell you there are errors. I think that's one. The other is that, unfortunately, death in America in hospitals is an equal opportunity employer. It equally applies to everybody. When you have a policy that's directed and that allows this such that more freedom you grant, the people that benefit the most are people in society who are the most privileged, who can make use of that freedom. And I think it's really, and that's one of the biggest concerns about, to me, as a person concerned with social justice, that when you expand the freedoms, yes, on its face, it's a good thing. But if it leads to consequences for people for whom the freedom for society leads to adverse consequences for people who are most vulnerable from those effects. I think that was my point. And I think that it's something to really think about.
Two quick questions. The first one is regarding the data on the end-of-life clinics at the beginning. Were they private clinics, public, profit organizations? Did you?
Yes, my best understanding is they were initially started with funding from NVVE, which is the largest Dutch euthanasia advocacy organization. So they funded it. It's a very large organization with membership fees. And they paid the doctors and the nurses who staff those clinics. I don't know if they've gotten to the point where they're able to bill for the services and they can get reimbursed and be self-sustaining. But at the beginning, that's how they ran those.
Thanks. And my second question was, I know that when they passed the bill, there was a debate. The physicians that were against it were saying that instead of putting in place this, well, assisted suicide, they would say, they wanted to improve the services, so then the palliative client wouldn't feel like they are a burden for their relatives. So I just want to know if there's a similar debate with mental health.
I mean, definitely. The mental health, I've always referred to mental health as the poor cousin in healthcare. They get very, very minimal funding. The services are highly oversubscribed. The people that are working in it experience extraordinary moral distress all the time. And part of that is because they end up in these situations that we're talking about where they don't know how to next help somebody. So absolutely, the palliative care, we can't get enough of it. Intensive mental health support systems, we can't get enough of them. Wildly creative ideas around helping people with their wish to end their lives. Some of you may have read articles in the paper in the last couple of years about South Korea, where they actually do fake funerals, which is an extraordinary piece of kind of mindfulness about what it would be like to actually be realistically ending your life. If you were going to actually proceed with it, you go through the whole process of putting on the shroud, getting in a coffin, but first of all, you write your will and you write letters to all your family and friends, and you do all these things. And it seems to offer great renewal to a lot of people who can get past their ongoing cognitive distortions around their life having been a failure. So, I mean, wild and crazy things have yet to be tried here, and I'm all for it.
Just to address that one point, so I think part of the debate maybe, or the thinking also, is that the reason why we're having these debates is because of the lack of the science and being able to predict, like in terminal illnesses. So I think there is a need for more funding in mental health to try to understand the biological determinants of the course of the illness, try to predict at the individual level, try to understand the social determinants, and to predict a course of. So we need to do more research in that area. We need the funding to do that, to address this ambiguity that we are in.
I'm neither a lawyer nor a doctor, nor actually a chronologist, but looking at my watch, I have a feeling this might be the last question.
Oh, okay, you're gonna hold on to it. Okay. I'm lucky then for asking the last question. I work for CCAC, and part of my job I do, or did do in hospitals, capacity evaluations for clients wanting to go into long-term care. And I think a lot of these issues are somewhat similar as far as capacity speaks, especially for our most vulnerable clients and patients. Is there more discussion about how capacity, or the ability to do capacity evaluations, is going to be rolled out for the physicians and nurse practitioners? Because I think that that's a huge gap. And if somebody is capable, whether they have a mental illness or a physical illness, I think that is a really important point. So I'm just wondering, what are the guidelines? Is there work going to be done for that piece? Thank you.
So at CAMH, we have a committee that when we get referrals to assess for capacity, and we follow a certain process. And I think today we only had one request to date where we actually did an assessment. And so we're trying to adapt the tool, the MacArthur tool for capacity assessment, to this issue. So that's to tell you about where we are at CAMH and adapting a tool that is well established to assess capacity in general, that's been adapted for different types of activities in healthcare to assess capacity for MAiD.
I just think one of the things to remember is that, like, the paradigms might need to be changed again, and certain things need to be unlearned. And suicidal thoughts work towards the diagnosis of depression. So, like, you're de facto being interpreted as having thoughts that are linked to suicide, or depression rather. So we got to find if there is a way to separate those out from the more rational, realistic assessment of the quality of my life, my own life, to get there. And I think that the trouble with capacity assessment, as I think Scott knows full well, because he's pretty much an expert on this, is it's so profoundly messy. And that, again, is a little bit of a shocker when you find out when you work in the field, because we already require physicians and psychiatrists to make seriously high stakes capacity assessment evaluations and seriously high stakes diagnostic evaluations, including things like finding people not criminally responsible for their actions when they've potentially killed somebody, and then going through the paces of assessing that person happily, where they may be recovering to a point that they can actually be back in the community again when they're stable and on medication. And it's actually one of those things that's interesting too, because I tend less to think about what polls or surveys say about the support in the population in general for things like assisted dying in different contexts. And I go back to thinking about, well, how can we reason through this? Because the support for, you know, somebody like Vincent Lee, who now goes by Will Baker, I think, being back in the community is really, really minimal among the population. The support for capital punishment in Canada is really, really high. It's well above 60 or 70%. So it's like terrifying. You can't do certain things, I don't think, by referendum. And I would argue this is one of them. So,
Dr. Kim, I think it's appropriate you get the last word.
Oh, it's not going to be that profound, so maybe I should let somebody else say it.
Shelley,
No, I just want to address these 2 points about our working with suicidal patients. I think it's a point well taken that we shouldn't just, as soon as you hear a patient say, you know, I want to die, it's suicidal. I think for experienced psychiatrists, we understand that. You know, I've treated patients who are both suicidal from their illness constantly, but, you know, I mean, you can't really hospitalize them forever. You take the risk and you do whatever. And then there are people whose circumstances are such that you understand that what it is that they're talking about when they wish for death. So I don't think that healthcare providers, psychiatrists are doing this knee-jerk, oh, you want to die, you're a psychiatric patient, therefore we're pathologizing you. I think we're talking about, even with very careful assessment, it's not an easy thing to do. If you know, all the cases that I've read of the Dutch cases, what's really fascinating to me is that even though this very point that Kevin makes, I think you used the term rational versus non-rational suicide. Let's say due to depression, let's say, is a person who commits suicide because it's driven by depression, and whatever that means, versus a person who's autonomously looks at their depression and says, this is not something I want to live with. You know what? Even though that's a profoundly relevant distinction, when I read the doctors' discussions that are being reported in these cases, I can't make heads or tails of what they're talking about, because there really isn't something that we in the field can talk to, point to say, yes, we know how to distinguish those new things. So most of the cases in the evaluation will be in the gray zone in terms of, let's say, capacity. When people can talk, when they can understand things, when they express the preference, but they may be not capable. Those are the tough cases. And what usually happens is that the context in which you do it makes a huge difference. And clearly what's happened in the Netherlands is that euthanasia is very normalized in the country, because, you know, U.S. equivalent of number of euthanasia in the U.S., if it occurred in the U.S., would be well over 100,000 a year. Okay, so everybody knows somebody who, whatever, so it's a very common kind of thing. Once the law allows it and it becomes a regular practice, even though when we're talking about it now, about capacity as a safeguard, we use that as a, oh, that's going to be a safeguard. In practice, once it's normalized, it's not really a safeguard. It's just part of the routine. And if you read the reports, that's what happens. They use very low threshold for, that's why in virtually over half the cases, when it involves people who are with diagnoses and symptoms clearly associated with increased risk of capacity, there's no discussion. It's like they're competent. Because they've arrived at a point where we should err on the side of giving people access. In fact, the Dutch Psychiatric Association official document guiding this, just the kind of guidance that we're talking about that should be developed. They developed one in Netherlands, written mostly by theologians and philosophers, not psychiatrists, but there it is, which says, well, you know, a person might seem incompetent and in fact may fail an assessment, but given how much they're suffering, I think you should, in those cases, maybe you should consider them competent. This is my rough, translation of what, recollection. So I think that it's important to think about what it means as a safeguard when you're contemplating legalization and the actual use of it once it becomes routine. And I think there's a big difference there. Thank you. Sorry it wasn't so profound.
Well, thank you. And thank you for your questions. I won't apologize for the fact that there weren't more of them, but I will say this is an ongoing, and this is just the opening of a longer conversation. Just before closing, I'll give a slight personal statement. I received the invitation to come here in early December. In fact, I received that invitation only moments after getting off an airplane when I had come from Paris. I had a chance, and I took it, to get 2 days of interviewing Jean Vanier in France. And the irony of receiving this invitation after just being there was too much for me to handle, almost. I mean, I didn't even understand how I could function in this context. I am happy to say that there is a lot more to think about. I'm also happy personally to say I'm leaving the room with more questions than answers, which I think is good. I think it's time, though, the country starts getting some answers, and that you have to ask questions in order to do the answers. This is an ongoing process. I hope you've enjoyed the evening. You can enjoy it more if you want to go to either the websites and see the evening on the either CAMH or U of T Law School website. Also, the feedback that you give about this particular evening will be very useful as the ongoing discussion is planned, so please feel free to do that. Other than that, I hope you had a stimulating time. I did. Please join me in thanking the panelists. Thank you for coming out, and have a safe trip home.